Hey everyone, my name is Derrick Broze, and you are listening to the Conscious Resistance Network, otherwise known as TCR or TCRN. Today we're going to be talking about Jeffrey Epstein and a few more updates that are important. These are important updates. And before we do that, I'd like to suggest, remind, humbly request that you check out theconsciousresistance.com so you can get plugged in with all of our latest content. You're going to want to sign up for our newsletter, which is weekly, bi-weekly, sometimes once a month, as often as I remember, but you're going to want to get it to make sure you keep up with our work. Other than that, I'd like to ask you to follow us on Minds, follow us on Steemit/DTube, join our Discord chat channel, join our text list to get updates right to your phone. I send out a text every time I put out a new video, including this one. And you can also follow us on bitshoot.com for our videos. If you'd like to support, you can do so via Subscribestar or patreon.com/Derrick Broze. And you can also get a free ounce of kratom or maybe some CBD through My Brave Botanicals, and that supports our work as well. So earlier today, I saw this report on Courthouse News from just earlier. Sealed Jeffrey Epstein files potentially implicate hundreds. Shortly before Epstein was found dead, or at least that's what we're told, a federal court had unsealed a vast trove of the files implicating heads of state, elected officials, and other elite figures and Epstein's web. This list could radically expand should the remainder of the sealed files become public, a federal judge heard on Wednesday. According to Jeffrey Pagluccia, an attorney for Ghislaine Maxwell, at a hearing this morning said, quote, "There are literally hundreds of pages of investigative reports that mention hundreds of people." So they're still pushing this idea that the rest of the pages should be kept private because more people are going to be implicated. We already know names like Prince Andrew, Harvard professor and lawyer Alan Dershowitz. We know of New Mexico Governor Bill Richardson, Glenn Dubin, and Jean-Luc Brunel, as well as former Senator George Mitchell, that these men have been accused. Now, it doesn't mean we have clear evidence or anything like that, but these are some of the names that have been mentioned. And there might be other names like, say, a Donald Trump or maybe a Bill Clinton or even a Hillary Clinton. And the other thing to remember is outside of just the salacious details of like, oh, which politicians are going to get wrapped up in this, there are other people. And I don't care if they are the top level politicians or the low level. All of them, anybody who played a role in this should be exposed and held accountable. And hopefully you guys agree with that. So Ghislaine is still trying to fight this and get these files released. Virginia Ghislaine, formerly known as Virginia Roberts, her lawsuit was settled years ago, but lots of these files were under seal, and this is what has been going on now. This recent battle is about open records, fighting to get these to be released. The lawyer for Maxwell alluded to an address book that has more than 1,000 names in it, but he did not distinguish whether or not this is the actual, so-called little black book that many of us have already talked about, and I know that I covered in my documentary, Bringing Down Jeffrey Epstein. So this could either be the little black book we already know about, and nothing, very new, or it could be something totally brand new. We'll have to wait and see. Insisting that the sealed files vindicate his client, Dershowitz's attorney, Andrew Seeley, has now, calling for maximum disclosure, claiming that it'll make Dershowitz's innocence appear crystal clear. We'll have to wait and see on that. Judge Loretta Preska, who will decide which files will become public, made clear she was not interested in hearing broad talking points. "I don't care," she straight up said. Instead, she pressed the lawyers on specific procedures for releasing the files expeditiously. She appeared frustrated that the attorneys arrived at today's hearing without any agreement on any files that could be immediately unsealed. She says, "It sounds like there's some disagreement," or the attorney said, "It sounds like there's some disagreement, Your Honor," said Ghislaine's attorney. The judge said, "No kidding." So the day before the hearing, however, this is an interesting little bit, attorneys for an anonymous third party, some doe, submitted a 7-page letter arguing against throwing new names into what they called a media frenzy. One of the attorneys writing for their John Doe client said, quote, "Unsealing references to non-parties would throw those non-parties into the middle of this frenzy and unfairly do irreparable harm to their privacy and reputational interests. Indeed, a vast number of these articles have published unsubstantiated allegations as fact. The careless regurgitation of allegations made under the litigation privilege has the potential to permanently and unjustifiably harm non-parties and their families." I will say that this is true, that there are a lot of people out there just repeating allegations as fact. And if we're going to be legitimate in this, and I know for me, striving to be legitimate in my work, we can't just go on, oh, well, they said the person I don't like is a pedophile. I'm just going to repeat it blindly. There has to be evidence. There should be evidence. So we're going to continue to fight for evidence, and we're not just going to publish or run with names, salacious names, and say, oh, so-and-so is a pedophile. We're going to push and look for the evidence, and if somebody is accused, we will dig in and try to see what evidence we can find on our own and what else we might be able to suss out from other sources. So Preska ordered the parties to submit written briefings on possible procedures for releasing the files that would give those named in the documents the opportunity to contest their release. So she's basically saying, like, tell me how we're going to go about this. How can you create a procedure for releasing the files that also gives the people who are potentially to be named some opportunity to say, please don't do this, which might reveal a little bit about them as well. Now, here's the Maxwell Gouffre document that was filed by Preska, the attorney of Maxwell. And it says, we write on behalf of an anonymous third party, John Doe, in advance of the conference scheduled for tomorrow, which was prior to today. And as I just said, they're basically calling for the judge to keep these records of John Doe, whoever that may be, private. Judge Sweet observed that the sealed materials implicate non-parties and include non-adjudicated claims on non-public private matters. So that's one reason. Then it says the Court of Appeals stated concern for the publication of libelous statements protected by the litigation privilege, emphasizes this court's responsibility to protect the interests of non-parties. They're just giving their arguments for why the judge should not release these files. Two categories of the sealed materials should readily remain sealed. Now, this is interesting. What parts do they want to be sealed? First, discovery materials, including written responses and depositions, interesting, or excerpts of the same that were not relevant to the performance of the functions of this case, are not judicial records and are entitled to no presumption of access and should remain sealed pursuant to the terms of the protective order. So they cite some case law. It says, nonetheless, should the court consider unsealing portions of these discovery materials, its review necessarily requires a page-by-page review. For example, simply because one page of a deposition transcript is deemed a judicial record does not mean another page, which pertains to a different subject or person, is as well. So they're trying to make it as difficult as possible. The second category of sealed materials consists of those records deemed to be judicial records, but that only, quote, played a negligible role in the performance of the duties of this court, basically. These records may, in fact, have had the tendency to influence a district court's ruling. The role of the information was ultimately negligible. The presumption of access accorded with such information is so low that it amounts to little more than predication of public access. So, in practical terms, as to records within this category where a non-party's privacy or reputational interests are implicated, these records should also remain sealed in their entirety. They move on and says privacy and reputational harm to non-parties outweigh the lower presumption of access to the final category of sealed materials. So they're just saying my client's privacy is more important than the public's access to these documents, which they claim are irrelevant to the final findings. And they give their protocol. Fashioning a mechanism to protect the privacy and reputational interest is a challenging task, but is a critical one. According, if the court is inclined to unseal the names of the non-parties, John Doe respectfully requests that the court adopt a protocol designed to protect non-parties and give them an opportunity to be heard. This is what we were just talking about. The judge said that they need to put it in writing. How do they want this process to go? And it says, John Doe respectfully submits that in this case, the court should do just that and should therefore maintain the sealed materials under seal, or at the very least, redact from them the names or other identifying information. So look, if we get the files and it's all redacted, it's going to be bullshit. So we need complete, full release of this because we won't ever get the truth. And we do have to exercise caution, as I said, and not just assume that this implicates people and this means you're automatically guilty. That's not true. We need to see what's going on and then make proper judgment. So I started looking around on Pacer. You guys know I have a Pacer account, so I use it to find various cases, especially related to Epstein. And I'm looking for some more, just looking through the court records. What I'm trying to find at the moment is Judge Kenneth Mara, who's in the Southern District of Florida. He's the one you may remember a couple of months ago who ruled that the non-prosecution agreement that Alexander Acosta helped broker 2008 to get Epstein his sweetheart deal, that violated the Crime Victims' Rights Act. And so we've been waiting for months to see what the judge is going to do now that he has ruled that the agreement violated the law. So he can either vacate the whole agreement or he can make different rulings. But we already know that he said the agreement was illegal, but depending on his next step, things could go one direction or the other. So you have this, despite Epstein being dead, there's allegedly, or at least, off the hook, there's these calls for investigations by other agencies that are allegedly, apparently, they claim, still going on. So more people could still be charged. And at the same time, you have this case here that we were looking at where Virginia Giuffre is going against Maxwell trying to get all these various files released. That's still going on. And then you have Judge Kenneth Morrow down in Florida who will make some move soon on what happens with the Epstein non-prosecution agreement and how does that open up for more potential charges. Because if that agreement is indeed vacated completely, whether just in Florida or elsewhere, that means the uncharged, unnamed co-conspirators would be able to be charged and could potentially have criminal charges filed against them. So just a bit of an update in this whole saga. I will keep my eyes and ears on it. Like I said, I'm not going to do every Epstein story out there when they're like, oh, look, here's Epstein in 1973 sitting on a boat. I'm just not going to waste my time putting a video together for that. But when there's important court updates, as I have been doing for the last 3-4 years on Epstein, I will let you know. All right, guys, that's it for now. I appreciate all the support. Again, consider supporting via Patreon or Subscribestar. And until next time, remember, you are powerful, you are beautiful, and you are free. Peace.